everyone. Welcome to the first session on resolution of disputes in commercial contracts. Today we are going to talk about the most efficient and the most preferred method of dispute resolution in commercial contracts, and which is arbitration. Now, the law of arbitration in India has evolved over a period of time, and with the passage of 2015 Amendment Act, the arbitration law in India has been substantially overhauled. The changes which came in with the 2015 Amendment Act has led to the Arbitration Act becoming much more efficient in terms of speed and in terms of cost, and which has led to it becoming one of the most preferred method between the parties to resolve any dispute. What do we need to see if we want to refer a dispute to arbitration under the Arbitration and Conciliation Act? In what form does the agreement to arbitrate exist? Now, all these questions are basically answered in Section 7 of the Arbitration and Conciliation Act. Section 7 of the Arbitration Act says that the agreement to arbitrate can be itself in the contract between the parties, or it can exist in any other form. It can be in the form of a communication between the parties, it can be in the form of a letter, it can be in the form of a telex. So the underlying idea of Section 7 is that there has to be an agreement or an understanding between the parties to arbitrate their disputes. Now, so long as there is an understanding between the parties, and which is in accordance with Section 10, the requirement or the basic essentials of reference to arbitration is fulfilled for the purposes of Arbitration Act. Now, the scheme of the Arbitration Act provides that when there is an arbitration agreement existing between the parties, no judicial authority shall exercise any jurisdiction or interfere in any matter which is the subject matter of that of the arbitration agreement. Now, this particular issue is clarified by Section 5 and Section 8 of the Arbitration and Conciliation Act. Now, Section 5 says that no judicial authority should interfere in respect of anything which is under the said part of the Arbitration Act, whereas Section 8 goes one step further and says that where there is an action which is not being brought before any judicial authority and which is a subject matter of the arbitration agreement, and under which is again subject matter of the Arbitration Act, that particular subject matter has to be referred to arbitration, and the judicial authority must not proceed further and adjudicate on those issues. So therefore, the purport of the arbitration agreement between the parties is very clear insofar as the scheme of the Act is concerned, that when there is an arbitration agreement between the parties, then there is no other judicial authority which shall interfere. And in case there is any matter which is already been filed before a judicial authority, then that judicial authority must not continue with those matter. And at the stage and after the parties making the judicial authority aware of the existence of an arbitration agreement, must transfer that existing matter to arbitration. Now, what do we do when we see the existence of an arbitration agreement in any commercial dispute? Now, the first course of action would be to appoint arbitrators. There has to be a request made to the other party. Now, ordinarily, when we draft a arbitration agreement in a contract, we would in ordinary course set out the mechanism for appointment of an arbitrator. The most prevalent mechanism of appointment of arbitrator is appointment of a sole arbitrator with the consent of both the parties. So under such method, ordinarily one party would propose an arbitrator to the other party, saying that that person is proposed to be the sole arbitrator. And when the other party agrees to the proposal of sole arbitrator, the said sole arbitrator would be appointed as the arbitrator to conduct the arbitration proceedings. The other mechanism, which again is very popular, is to appoint three arbitrators in any given dispute. Now, often the clause is structured to say that both the parties will appoint one of their own arbitrators. So therefore, that would make two arbitrators who are proposed. Then both the arbitrators who have been appointed by the parties, now they will go ahead and appoint the third arbitrator, who will be the presiding arbitrator in the matter. Now, these are the most common ways in which the arbitration agreements are structured, but there can be other ways in which the arbitration agreement can be structured as to the appointment of arbitrators. Now, what happens if the other party is not responding, or it is not interested in initiating arbitration? You may be the claimant and you may be suffering because of the non-appointment of arbitrator by the other side. Now, when we look at the Arbitration and Conciliation Act, again the answer comes in section 11 of the Act. Now, the right to appoint arbitrators have been given to two exclusive courts, which are Supreme Court and the High Court. Now, Supreme Court has the exclusive right to appoint arbitrator in respect of international commercial arbitration, whereas the High Courts have been granted the power to appoint arbitrators in respect of domestic arbitrations. Now, when you approach a High Court under section 11 subclause 6 for appointment of an arbitrator, now one of the most contentious areas before the courts has been, what does the court require to see at that stage? Now, pre-2015 amendment, the law was slightly unclear, and the issues such as whether the dispute is arbitrable or not, all those issues used to be raised before the court, and the courts would ordinarily make subjective determination of those issues, and only if the court was satisfied that the dispute was arbitrable for whatsoever reason, then would refer such disputes to arbitration. Now, the position changed slightly with the coming of the 2015 amendment. The 2015 amendment said that you are only required to see the existence of an arbitration act. So therefore, after that, there was a big seismic change in the way the courts looked at arbitration agreements, and they would appoint or refer the matter to arbitration as soon as they saw an arbitration agreement between the parties, and they would not further go into any other question. Now, what has happened with the 2019 amendment is that sections 11 subclause 6a has been omitted, and the legislative intent behind such omission is not very clear. And in my personal opinion, it is a back step in the development of the whole idea of reference of a dispute to arbitrations, as there are many subjective questions which are raised before the court, even without going before a tribunal. Now, an important aspect in this regard is section 16 of Arbitration and Conciliation Act, where it basically exemplifies the principles of competence, where a tribunal basically determines if the tribunal actually has jurisdiction to look into that dispute or not. Now, after the 2015 amendment, the understanding of the courts were such that all these issues of arbitrability could be decided by the tribunal itself under section 16 of the Arbitration and Conciliation Act. So therefore, in a way you can say that under the earlier regime, pre-2015, there was an overlap in terms of the issue of arbitrability, which could be adjudicated, as the same issues could be raised at the stage of section 11 subclause 6 at the time of appointment of an arbitrator, or subsequently after a tribunal comes into being by raising it before tribunal under section 16. So that per se, in my opinion, is slightly contentious, and we are slightly unclear of the legislative intent of omitting the section 11 subclause 6a. In terms of the fee for the arbitral tribunal, in cases of domestic arbitration, it is imperative to note fourth schedule of the Arbitration Act. Now, the fourth schedule of the Arbitration Act was introduced with the 2015 amendment, and it does not prescribe the fee to be charged in respect of international commercial arbitration, and is only limited to domestic arbitrations. Further, in respect of the time for completion of the arbitration proceedings, that is for passing of the award, now the Arbitration Act under Section 29 provides that the arbitral tribunal shall have a period of 1 year after the completion of pleadings in any proceeding. Now, the completion of pleadings in any matter, the period of 6 months has been prescribed. So, therefore, the period that is ordinarily prescribed under the Arbitration Act is the 6 month for completion of pleadings, then a further period of 1 year therefrom for passing of the award. Now, again, the parties have been given right to extend the period for passing an award by another 6 months, so which will make it 6 months plus 1 year plus 6 months in case both the parties agree. And if there is any further extension which has to be sought, or in case any of the parties doesn't agree to extension of the time for passing an award, then the remedy is to approach the court and seek extension of time for passing of the award. I beg your pardon, the time limit for passing of an award is provided in Section 29A as against 29 as earlier said by me. Now, coming to the aspect of impartiality of the arbitrators. Now, the 2015 amendment again came with special focus on ensuring that the arbitrators appointed in any matter are impartial and there is no justifiable doubt on their independence. Now, the provisions in respect thereof are provided in 12, 13 and 14. Now, the grounds are particularly given in Section 12. Now, if you look at Schedules 5, 6 and 7, Schedule 6 basically is the declaration which any arbitrator requires to give in case where he is approached for an appointment, setting out the details therein. Now, if you look at Schedule 7, now Schedule 7 more particularly refers to situations where of relations between the arbitrator and the parties, and if any of those relations as enumerated in Schedule 7 is found to exist between the arbitrator will per se be ineligible to be appointed as an arbitrator. Now, in respect of Schedule 5, the situation is slightly different, as in respect of Schedule 5, if any circumstance exists as enumerated in Schedule 5, it gives a justifiable doubt as to the impartiality of an arbitrator, but it is not a conclusive proof, or that does not per se bar the arbitrator from acting as an arbitrator in the matter. In the next session, we'll look at the other important parts of the Arbitration and Conciliation Act, such as the interim provision for interim measures under the Act, the challenge to an award under Section 34 of the Act, Section 37, which talks about appeal against orders, and then we'll look at other important concepts in the arbitration, such as the debate around seat of the arbitration and jurisdiction of court. Thank you very much.